I'm sorry, why are we sealing things again? Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. All right, so I decided to check the public case of interest website to see if there was any new documents, any information on that last order that was sent out. Now, we are obviously going to be getting the unsealed documents in batches of about 40 requests or so. They did not all become publicly available the last time we went through these in videos and in lives. I will have links for those down in the description box. But as a refresher, I will scroll down this second order asking for things to be, argued about, whether they can be released or not. A lot of this is more information on the alternate perpetrator information, along with some more information regarding witness lists. This is extremely interesting now because what we have learned in the argument for them not releasing in full the alternate perpetrator information is that the state's witnesses, these alternate perpetrators, are included in those state's witnesses. And what I said is that this is keeping to theme to the defense claiming that they were going to be using the state's evidence against them to prove that their client was factually innocent. Now, I know that we now have a guilty plea and there's been a sentencing and all of the things. I understand that. I am just pointing out the fact that this is keeping to the same theme that they have been playing the whole time, stating again that they were going to use the state's evidence against them in order to prove his innocence. And I will also remind you guys, we heard a very similar type vibe coming from Pennsylvania. He not only stated that he was anxious to get back to Idaho in order to be exonerated, but that his GPS information on his phone would prove that he wasn't there and it would prove that he was innocent. This came from his Pennsylvania attorney that came out and did interviews really early on. And I will remind you guys again that as of now, we've only been hearing from people in law enforcement or on the state's side. And when it comes to the defense, anyone on their end, we haven't heard anything. And there's been crickets from Cy Ray, who just happens to be the person to prove if his statements, Bryan Kohberger's statements from back in Pennsylvania, would actually hold any weight or not. Again, I know we have the plea order, and I know that means a lot. Okay, I know that that does have some sort of tone that gets set. But whenever you step back and think about all of the questions and all of the things that they still have not proven with this guilty plea, and with them now having the availability without any sort of restrictions to come out and give us everything that they had, they're not proving that they had it. That's the biggest problem here. That's why we continue to try to figure out what's really going on, because they're still stating no connections. We can't put him in direct contact with the home. None of these things give us an answer. That's why when it comes to these documents being unsealed, it's important that we get as much information as we possibly can. And in this information is information from the closed sessions from back in May. Those were extremely important. On top of that, we also have, where'd it go? Right here, states and defendants trial brief. I was so excited to see this. On top of this, we also have the exhibits for the AT&T timing advance records. We have a lot of really important information in this drop. So when I saw that they wanted their response completely sealed, I was honestly more than a little disappointed, because I don't understand what the point of this is at this point. Because I feel like they are probably posting this in response to some of those very important things that we just discussed. And I just don't understand, what is the point of this at this point in time? Nothing was filed. I know there's still other things that can be done, but what is the point of sealing this stuff at this point in time, even if you are going to file something later on down the line? Why not just put all of the information out there? This, to me, is a bad look, that after all of this fighting to finally have all these things come out, you're now filing something completely sealed to the public. I don't personally like it. It just is what it is. This is all that this says. This is 4, motion to seal, defendant's supplemental response to the court's order regarding sealed documents. And again, this is coming after the second order. This would have nothing to do anymore with the first. Look at the date, 9/9/2025. I'm recording this after 10 p.m. on September the 10th, 2025. So this has nothing to do with those first drops whatsoever. Comes now Bryan Kohberger by and through his attorneys of record, and hereby moves the court for an order to seal defendant's supplemental response to the court's order regarding sealed documents. Now, maybe we can get a little bit of an idea about what the reasoning is if we check out the rules that they are citing here. So let's look ICAR 32I up and see what it says. So here's 32. Let's go down to here we go, I. Redactions and sealing of court records. 32I. Okay, so they don't give a specific for inside of I, and as you can see, there's quite a bit here. It goes on like for a while. So I don't really know which one they're specifically citing here. Other than, the basics, I guess, we'll start with just what the first one says, but I'm not going to read further than that because they're not giving me anywhere else to look for this. But let's just go with number 1, filing a motion. Parties to a case or non-parties whose rights are affected by or who otherwise have a right to access information contained in a court file may move to redact, disclose, seal, or unseal records in a case. I mean, that just sounds like, your normal rules. Okay, so this one here says to read Title 74, make this bigger. 74, 124, and which one? 1, B and C. Okay. 1 says, notwithstanding any statute or rule of court to the contrary, nothing in this chapter nor Chapter 10, Title 59 Idaho Code shall be construed to require disclosure of investigatory records compiled for law enforcement purposes by a law enforcement agency, but such exemption from disclosures applies only to the extent that the production of such records would. B says, deprive a person of a right to a fair trial or an impartial adjudication, constitute an unwarranted invasion of personal privacy. So this one is repetitive to, the previous one, but why is this one now being cited considering where we are right now? That's interesting. That's it, but again, it's sort of a negative to me that the defense is filing things under seal at this point. But again, and it also could be because they are planning on doing something else. That law that they are citing about a fair trial, considering that we are past the sentencing phase and he's in prison and his sentence has started, it's interesting. I don't know. Let me know what you guys are thinking, though, down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.